Good afternoon. Welcome to Assembly Natural Resources. Madam Secretary, please take the roll.
Assemblywoman Anderson. Present. Assemblywoman Bilbray Axelrod. Here. Assemblywoman Brown May. Here. Assemblywoman Considine. Present. Assemblyman DeLong.
Present.
Assemblywoman Duran. Here. Assemblyman Gurr. Here. Assemblywoman Hanson. Here. Assemblywoman LaRue Hatch. Here. Assemblyman Watts. I am here. Assemblyman Urick. Here. Chair Cohen.
Thank you, and I am here. Again, welcome to Natural Resources. Special thank you to Assembly members Urick and Duran, who have just got out of Commerce after another marathon hearing since, I think, 12:30. And an extra special greeting to Assemblymember Urick, who, after we're done here, will be presenting a bill in another committee. So if you're a person who prays, I'm sure Assemblymember Urick would appreciate your prayers. Some quick housekeeping, please silence your electronic devices. If you wish to testify, please sign in at the table by the door and provide business cards to the committee secretary, although this is just a work session, so there should not be testimony. When testifying, please turn on the microphone, clearly state your name and affiliation, if any, for the record, then turn the microphone off each time you're done speaking. If you have handouts, there should be 15 copies for the members of the public. Electronic copies should have been submitted to our committee manager by by noon yesterday for the committee. Most importantly, we expect respect and courtesy in our interactions during the meeting, even if we may not agree with each other's positions. And please note, committee members will be using laptops to view handouts and other documents. Please do not view this as a sign of disrespect or inattention. So we will be having a work session today as well as public comment. We do have some of the presenters here, and we will ask them to go through some of their amendments with us. However, hopefully we'll be able to get through our work session fairly quickly. So with that, we will get started with our work session and Assembly Bill 34.
Thank you, Chair. For the record, Becky Peratt, Committee Policy Analyst. Assembly Bill 34 revises certain provisions relating to the state engineer's notice requirements. Specifically, AB 34 provides that the state engineer is not required to republish notice if the newspaper fails to publish the notice for the required number of times, but notice was published at least once for certain notices and orders. The bill also requires the state engineer to mail copies of the notice or order to at least one public library or other public place. Additionally, AB 34 revises the time period for individuals to file written protest against the granting of various applications relating to the appropriation or diversion of water. And finally, the bill removes requirements that certain maps relating to water rights be on Mylar and tracing linen. The Division of Water Resources proposed an amendment which, amongst other things, removes language allowing the state engineer to not republish notice if the newspaper fails to publish notice for the required number of times, but notice was published at least once, removes the requirement for the state engineer to mail copies of the notice or order to at least one public library or other public place, strikes language currently in statute requiring certain notices and orders be published consecutively, adds requirements that the division post various orders and notices on their website, revises the time period for individuals to file written protest against the granting of various applications relating to the appropriation or diversion of water, and allows a presumption that if no protest is received 60 days after submitting notice to a newspaper, the division can presume notice was published and can process the application, but cannot issue a permit until proof of publication has been received.
Committee, do we have any questions? Okay, seeing none, I will take a motion to amend and do pass.
So moved.
Okay, I have a motion from the vice chair. I have a second from Assemblymember DeLong. Do we have any comments? Seeing none, all those in favor, please say aye.
Aye.
All opposed, nay. Okay, so I have a nay from Assemblymember Hanson. The bill does move forward, and I will ask Assemblymember Gurr to please do the floor statement. Welcome.
Assembly Bill 86 prohibits individuals from restraining a dog with an improperly fitted collar or harness or with a weighted tether, chain, tie, trolley, or pulley system. The bill also prohibits leaving a dog outside and unattended unless the dog has access to adequate shelter, an area to avoid standing water and excessive animal waste, shade, and potable water. Assemblywoman Hardy, in consultation with Washoe County, proposed an amendment to add prohibitions relating to the treatment of animals, create an exception to certain prohibitions for individuals who are indigent, define abandonment and clarify the prohibition against abandonment, include additional requirements constituting adequate shelter for dogs left unattended outside without immediate access to being indoors, and add additional categories of exclusion from the restraint and shelter requirements. Chair Cohen proposed a friendly amendment to include in the exception to the definition of abandonment, animals taken to a pound or animal shelter.
Committee, do we have any questions? Okay, please go ahead, Vice Chair.
Thank you. During the presentation, I believe there was a question about the air quality, especially in the lobby room. But then also, and so I was just wondering if that actually has been addressed in this, because I think that was one of the questions that had to do with it, and I just can't seem to find it.
Good afternoon, Madam Chair, members of the committee. For the record, my name is Cadence Matievich, representing Washoe County. Through you, Madam Chair, to Assemblywoman Anderson. I think the question, the piece that you're referencing, it's on page 6 of your work session document, page 2 of 7 of our proposed amendment. At line 7, there had been language in the bill regarding wholesome air. And I think there had been questions around the definition of wholesome air. That is actually existing language that is in this chapter elsewhere. But in discussion with some of the other entities that had interest in this bill, we decided that it would probably be best. We believe that the issue around proper ventilation addresses the things that you heard that day, where if there were to be a high concentration of any kind of smell or improper airflow, that the proper ventilation language that's there does address that issue.
Okay, thank you both. Okay, seeing no other questions, I'll take a motion to amend and do pass. Okay, I have a motion from Assemblymember Gurr. Do I have a second from Assemblymember Bilbray Axelrod? Any comments? Seeing none, all those in favor, please say aye. Aye. All opposed, nay. Okay, that passes unanimously. I'll ask Assemblymember Hardy to take her floor statement, and I'll ask Assemblymember Bilbray Axelrod to back up just in case.
Thank you, Chair, and thank you for everyone that helped work on this bill. I appreciate it.
Assembly Bill 91 allows individuals to sink or bore a replacement well without submitting an application to change the place of diversion of water already appropriated if both the original well and replacement well are on public lands and the replacement well is within 300 feet of the original place of diversion. An amendment was submitted by Assemblyman DeLong in reference to a letter submitted by the United States Forest Service, which is posted on Nellis, and copies have been provided to members and to the public to provide a definition for public lands. And compliance with federal law.
Thank you. Committee, do we have any questions about this bill? Okay. Question or comment?
To more or less kind of go over this.
Right question? Okay, please go ahead.
Now with this amendment coming on, this was just given to us, can we kind of walk through it real quick to see? Because I know I was a no at first, and if there's some other things that might be, change my mind.
Would you like to address it?
I will. Thank you, Chair. I'll attempt to address it. The amendment will add a definition of public land, which already exists in NRS, and we'll likely just cross-reference that. And then add language that says, before you conduct activity on public land, you'd contact the appropriate either state, federal, or local agency.
Okay, do we have any other questions? And committee, I will let you know, I had not seen the letter, and I'm sorry for the oversight. I would have provided it sooner had I realized that we had received it from the Department of, was it Forestry, the U.S. Department of Agriculture, Forest Service. But, you know, if anyone needs to take a moment to read it, please do. But I think it's kind of minor amendments that just address putting into the bill the language that we already have in statute and saying that you need to comply with federal law, which you kind of need to, you already do need to comply with federal law. So, okay, so unless we have any other questions, right, I will take a motion to amend and do pass.
So moved.
Okay, I have a motion from the vice chair. I have a second from Assemblymember DeLong. So I have a comment from Assemblymember Bilbray Axelrod.
Thank you, Madam Chair, and thank you for the indulgence. In this building, there's a lot going on, right? We have relationships with people, and I appreciate the sponsor of this bill, and I appreciate him, coming around and talking and doing exactly what you should do on a bill. However, for me, this building also holds a lot of legacy. So my father was a champion of public lands, both in this building when he served on the committee as well as in the United States Congress. And I know that he felt Nevada lands in particular, the public lands, were very special. And while I can't, as I mentioned, I can't call him to ask, I just feel like if he were here, he would not be in agreement with this. And so I am going to be a no, but once again, I appreciate the sponsor for your work, and thank you.
Okay, do I have any other comments? Okay, seeing none, all those in favor, please say aye. Aye. All opposed, nay. Nay. Okay, so I have a nay from Assemblymember Bilbray Axelrod, and you always reserve your right. We just ask that you inform us before, if you make any change before we get to the floor. But so are you what is your vote? Okay, so you're a yay. Okay, so the only nay I have is Assemblymember Bilbray Axelrod. Okay, so with that, it does pass amended, and I will ask Assemblymember DeLong to do the floor statement.
Assembly Bill 162 requires the Director of the State Department of Agriculture to classify neonicotinoid pesticides as restricted use pesticides, defines and lists neonicotinoid pesticides, and prohibits the use of neonicotinoid pesticides on state land. Additionally, AB 162 exempts neonicotinoid pesticides from certain registration and examination fees. Assemblywoman Gorlow proposed an amendment that removes these provisions and instead lists permissible uses of neonicotinoid pesticides, prohibits the sale, delivery, or use of neonicotinoid pesticides on plants not grown for commercial agricultural purposes, limits the permissible purchase of neonicotinoid pesticides for use on plants to those who possess a certificate of commercial agricultural use, defines commercial agricultural purposes and certificate of commercial agricultural use, and adds co-sponsors to the bill. Trey Abney, on behalf of the American Chemistry Council, submitted a friendly amendment that adds structural insulation to the list of permissible uses.
Committee, do we have any questions? Okay, seeing none, I will take a motion to amend and do pass.
So moved.
Okay, I have a motion from the vice chair and the second from Assemblymember Considine. Do I have any comments? Okay, seeing none, all those in favor, please say aye. Aye. Opposed, nay? Okay, that passes unanimously. I will ask Assemblywoman Gorlow to take the floor statement and Assemblywoman LaRue Hatch to be back up.
Assembly Bill 313 revises various definitions and requirements related to mining exploration, projects and operations, and plans for reclamation. To clarify for the record, the bill provides an exception from reclamation requirements for open pits and rock faces, which may not be feasible to reclaim only if no pit lake is anticipated to result, and also provides criteria for other exceptions, which must be shown by either clear and convincing evidence or a preponderance of the evidence. Assembly Bill 313 also requires an operator of a mining operation to submit a revised plan for reclamation to the Division of Environmental Protection in certain circumstances. Additionally, AB 313 requires a person who submits an application for an exploration project or mining operation to assume responsibility for the reclamation of surface water or groundwater affected. Finally, AB 313 requires that annual mining operation or exploration project reports submitted to the division also include a map of disturbances to the water balance and to the quality and quantity of surface water and groundwater. Assemblywoman Peters submitted an amendment that, amongst other things, removes language requiring existing permits be considered and other retroactive language, revises the requirements that an operator must demonstrate when requesting an exception to the requirement that plans of reclamation provide for the backfilling of an open pit, removes the provision that the Division of Environmental Protection may not consider the economics of the operator when determining whether to approve or deny exception applications, adds a requirement for the Division of Minerals and Division of Environmental Protection to prepare a report to be submitted to the Joint Interim Standing Committee on Natural Resources, and requires the Department of Wildlife to submit recommendations regarding analysis of mine impacts to terrestrial and aquatic wildlife and their habitats. The Assemblywoman also submitted a second amendment, which has been uploaded to Nellis, and copies have been provided to members of the public and members of the committee.
Assemblywoman, do you want to come explain the second amendment?
Thank you, Madam Chair. So we took the basement amendment that Sarah Peters, for the record, that we brought on Monday. It's only been a couple of days, and took into account some of the comments and questions that were brought up from the committee, including a revision to Section 4, Sub 2A, in which we removed the expectation for new permits issued by January 1, 2024, and replaced it with new applications submitted after January 1st, 2025, to give a little bit more time for the division to get stuff going for those folks who would fall under this provision. And then we added the removal or the revision to Section 12, which removed or modified 200-acre exception for pit lakes. In the original draft, it had modified that 200 to 85. We removed that modification and left it at 200 acres for that exception for pit lakes. The rest of it remains the same.
And committee, obviously, this isn't a chance to rehear the hearing or to redo the hearing, but if anyone does have some questions, we can ask. Okay, so do we have any questions? Okay, seeing none, I'll take a motion to amend and do pass. Okay, I have a motion from Assemblymember LaRue Hatch. I have a second from Assemblymember Bilbray Axelrod, and then, I'm sorry? Oh, sorry, I'm sorry, I have, motion. So the motion was from Assemblymember Duran. The second was from Assemblymember LaRue Hatch. Did you second? Okay, okay.
I can third.
Let's, Duran and Bilbray Axelrod. With that, we do have some comments, so I will take a comment from the vice chair first.
Thank you, Chair, and I want to thank the sponsor as well as all the other individuals who I've had a chance to talk with over the last 2 days, from both sides. The discussion has been robust. It has been, there's just a large amount of varying definitions that are being thrown around, and I will be voting for this today. I continue, though, to have concerns, and I have voiced those concerns to both sides. And I look forward to possible solutions as this moves forward. But I again want to thank both sides for the number of discussions that have taken place over, I think, for a few of them over the last hour and a half. But recognizing that continues to be concerns and continues to be a very different point of view when it comes to the analysis of different scientific areas as well as definitions being used. So again, want to thank everybody, though, for that conversation. And I'm voting yes so the conversations can continue. Thank you.
Thank you, Vice Chair. Assemblymember DeLong.
Thank you, Chair. Given the testimony we had, when was that? Yesterday? Monday? It's happened so quickly. Both from the opposition as well as the neutral testimony from NDEP, the uncertainty that this bill would bring to the regulatory process for permitting mines in Nevada, I find it quite ironic that we're doing this the day after a floor speech by our senior U.S. Senator promoting Nevada as the best jurisdiction for mining.
Okay, committee, do we have any other, Assemblywoman Brown May?
Thank you, Chair. I'd like to echo some of the comments of my colleague on the dais. There's been a lot of really good work around this bill. I've met with the bill sponsor. I met with state divisions. I met with mining. I met with as many interested parties as I could. I agree that we have some additional work to do here, and I'm excited to be able to continue that effort alongside the bill sponsor as we work on this. I think it's important that we understand the intention of this bill is to solidify the long-term use of our native lands and the importance of reclamation as we move forward. And that we also have a simultaneous responsibility to ensuring that a significant industry, is treated fairly in their business operations, and they're allowed to continue to apply to do mining, following up from my colleague's comments, right, and our speech last night. I think that there's a middle ground that we can reach, that we can preserve our native lands, we can preserve our native culture here in the state while we're still working through these issues. I'm concerned about having the state divisions involved in determining economic practicality of our mining operations, so I'd like to work through that bit a little bit. And I think there's some bifurcation in our NRS regarding oversight for water quality versus water quantity, and I think we need some clarity around that. The divisions of mineral and environmental protection need to work closely together to prepare that report. I think we have some gray area that we can work through there that I've discussed with the bill sponsor. And I have some questions about new mining projects as they relate to lands that have been previously mined, and what are the potential implications for some of the groundwater contaminations there. So I am a yes out of committee today. I have promised the bill sponsor that I will continue to work with the active and interested parties relative to this bill to see if we can move it farther along.
Okay, any other comments? Assemblymember LaRue Hatch.
Thank you, Chair, for your indulgence. I think we all want to talk about this bill. I just want to thank the sponsor for the clear amount of work that has gone into this, the fact that I think she is trying to acknowledge the concerns that people had. I appreciate this move towards preserving our water and relying on science, and I think there are some exciting things on the horizon for us as far as conservation and balancing our mining needs and everything else. And so I just wanted to put that on the record that I will be voting yes, and I am excited for the conversations that will continue.
Any other comments? So I think, I'm reminded of a comment I made at the end of the interim committee on Lake Tahoe and Marlette Lake, which the bill sponsor chaired, and how it was so nice to have a chair that just really understood the issue and really understood water. And I know that she will bring that knowledge and passion to continue to work on this bill. I appreciate everyone's efforts on this bill, and I'm hopeful we can get to a place where there can be some consensus, because it's hard to believe that we can't come to a place where there's at least something in the bill we can all agree to. So with that, I will ask all those in favor, please say aye. Aye. All those opposed, nay. Okay, can I have the nays please raise your hands? So I have Gurr, DeLong, Urick, and Hanson. So the measure does pass. I will ask the bill sponsor to read the floor statement and ask Assemblymember LaRue Hatch to back up.
Assembly Bill 387 requires, rather than encourages, the state engineer to use the best available science in rendering decisions concerning surface and underground sources of water in the state, and revises the definition of a basin or groundwater basin. The bill requires the state engineer to consider, for purposes of determining whether unappropriated water is available, and deny an application to appropriate water for beneficial use if the proposed use or change conflicts with existing rights, including the existing rights of permit holders, claimants of vested rights, or the existing rights associated with any hydrologically connected surface or groundwater. Finally, the bill adds language that any appropriation of underground waters in the state is subject to all existing rights to the use thereof, regardless of where the respective points of diversion are located, and whether the respective points of diversion are located in separate basins, if the state engineer finds a sufficient hydrologic connection exists. Assemblyman Watts submitted an amendment that, amongst other things, provides a definition for best available science and removes the revised definition of a basin or groundwater basin, requires the state engineer to deny applications to appropriate water for beneficial use if, and to determine the availability of unappropriated groundwater based on whether the proposed use or change conflicts with existing rights, including an existing right that stems from any hydrologically connected surface water or groundwater, revises language relating to appropriation of underground waters to provide that any appropriation or use of underground waters is subject to all existing rights to the use of the source thereof, if the state engineer finds a hydrologic connection sufficient to cause a conflict with existing rights, and requires instead of empowers the state engineer to make certain rules and regulations.
Committee, do we have any questions? Okay, I have a question from Assemblymember DeLong.
Thank you, Chair. I wish to seek clarification in order to firmly establish the legislative intent. I want to make certain that the language does not constitute authority for the state engineer to create a super basin and manage jointly multiple groundwater basins. I want to ensure that what we are talking about with this language is limited to the management of a source that has groundwater connection and is sufficient to cause a conflict with existing rights. Other water rights within a basin which do not demonstrate to have a hydrologic connection sufficient to cause conflict with existing rights will not be included in management activities related to this issue. Is that correct?
Thank you, Madam Chair. Thank you for the question, Assemblyman. Yes, so I'll say at its core, the removal of the language relating to the definition of groundwater basins, which was in the original draft of the bill, but was actually not something that I originally sought out, was to make sure that we really do hone this in and that this is not about managing multiple basins together, but really focused on the core issue at hand, which is managing conflicts. And there is already some existing law that acknowledges the state engineer's ability to manage an existing water right that lies within a basin that's managed jointly with one or more basins. That's in NRS 360.992. And again, this isn't touching that or pulling that into the subject matter that we're working on here. which is really to clarify the law. I guess the one other thing I'll say is I've had some extensive conversations, and this bill has an effective date. There's no effective date printed, so it would be on October 1st. This is something that is meant to be applied going forward, and I hope that it provides clarity that helps the state engineer and all stakeholders navigate potential conflicts moving forward in the best way possible. Its purpose is not to intervene or alter the outcome of any existing litigation.
Committee, any other questions? Seeing none, I'll take a motion to amend and do pass.
So moved.
I have a motion from the vice chair. Do I have a second? I have a second from Assembly Member LaRue Hatch. Any comments? I have a comment from Assemblywoman Bilbray Axelrod.
Thank you, Madam Chair. And unfortunately, I was like very, very, very sick on the day we heard this bill. So I wasn't even watching it, and it just occurred to me that I hadn't gone back to see it because it's been a little busy in education. So I am going to vote to move this, but I do want to go back and watch the committee, and I'll continue to talk with the sponsor.
Any other comments? Okay, and thank you. Certainly, we appreciate Assemblymember Watt's effort. I don't know if he's ever had to work as hard on any other bill before.
Of his 26 bills.
Please go ahead.
Thank you, Madam Chair. And I appreciate that, and I have put in a significant amount of time on this, but I also want to thank all the other stakeholders that have been engaged on this. We wanted to make sure that this was an open and transparent process, and that anyone who is interested in working towards the common objective of clarifying our water law is included. And there might still be some additional tweaks along the way, but it's been very heartening and impressive to see the diverse folks that have come together from urban areas, rural areas, different sectors of the economy, all working to try and reach consensus. And in water law, that's never an easy thing. So I just want to commend all of those, and also just extend the offer to anyone that is interested in working towards that shared objective. They are welcome into those conversations.
Thank you. Okay, seeing no other comments, all those in favor, please say aye.
Aye.
Opposed, nay? Okay, nays, please raise your hands. I have Assemblymember Gurr, Assemblymember DeLong, Assemblymember Urick, and Assemblymember Hanson. The matter does pass, and I will ask Assemblymember Watts to take the floor statement. So with that, we are done with our work session, and we will move on to public comment. Public comment is an opportunity to discuss any issues under the purview of this committee, but not to rehear any of the bills or addressed today in the work session. Do we have anyone in Carson City for public comment? Seeing none, not seeing anyone in Elko. If there's anyone in Las Vegas, please come forward. BPS, is there anyone on the phones for public comment?
Share, the public line is open and working, but there are no callers at this time.
Okay, so with that, we are going to go into recess. I don't believe we will be coming back, but we will go into recess just in case. We're adjourning? Okay, oh, I guess we're adjourning. Okay, so I guess we are adjourning. So with that, we are adjourned. Okay.